Hello everyone, Assalamu alaikum. I welcome you all to another episode of CIS Conversation series. This is Shahneela Tariq, lecturer at School of Integrated Social Sciences, the University of Lahore. Today we have a very distinguished guest with us all the way from Bolivia, a Latin American state bordered with Argentina, Brazil and Paraguay, to talk about extradition and political asylum. Extradition is a legal process in international law of surrendering an individual for the crimes which are punishable. Historically, states did not have obligation to extradite individuals in the absence of any international binding arrangement, and it was based on the informal settings of the leaders of sovereign states. However, the repeated and increasing crime rate created the need of binding arrangement, such as the European Convention on Extradition, which came into being in 1957. Extradition is regulated with the countries by extradition acts and with the countries by diplomatic treaties. Recently, rapid movement of goods and people has immensely contributed to the development of transnational criminality. To check this, United Nations Transnational Organized Crimes Treaty has come into force in 2003. Extradition is a highly important topic, and luckily we have an international expert to talk to us about extradition. Jorge Andrés Brun Aramayo was born in the city of La Paz, plurinational state of Bolivia. He is a lawyer, a university professor, and an expert speaker on the issues of international law. Currently, he is working with the Bolivian Public Administration at General Directorate of International Law under the Vice Ministry of Justice and Fundamental Rights of the Ministry of Justice and Transparency. Andres has a master's degree in international relations and a postgraduate degree in development studies. He has obtained a number of diplomas in legal studies, administration, and government control. He has also obtained a degree in law and legal sciences with a distinction. He regularly writes on the issues related to his field. Today, we will request him to discuss about his book, The Extradition, which was initially distributed in Latin America and now it has been distributed in other regions as well. Andres, I would like to thank you again for your time for joining us today for our faculty series. To start with, I would ask you to kindly highlight the difference between asylum seekers and refugees because there is a lot of confusion among even scholars, not if students. And also, I would want you to explain the legality of asylum. Thank you, Andres, again for joining us.
Thank you, Shahneela. Good evening. It's a great honor for me to be here today, talk about extradition, all those theoretical elements, and give rise to this important field of international law. For the first question, we can start to say the difference between asylum seekers and refugees. It's common to confuse the terms to asylum and refuge due to their similarity. However, they are not synonymous since each to the different requirement and implies different treatment. In both cases, the purpose of the obtain protect, however, what the main difference between asylum and refugee status. First, asylum is a right provided to the declared human rights that which a person seek protection outside of the country of origins as a result of a war or persecutions against him or her. The reasons may be religious, race, gender, sexual orientation, social group, nationality, or political opinion. It may be requested by a person who cannot return to his or her country of origins for their persecution. Under these circumstances, the person must apply to the asylum in the country where he or she is located and not shown out. The objective is to avoid to repressive actions to the territory with the confliction of persecution originates to avoid violence against the person. Refuge is, in general terms, refers to notion of a person who applied of asylum and being accepted. However, this concern is between broadened to the encompass circumstance which there is mass flight to the people due to the war, of natural disasters, not necessarily to the persecution of these persons. Any person fleeing their country with a specific profile large group of peoples. Refuge is a humanitarian term, and there is some granted to persons to have a well-founded fear of persecutions. These institutions allow for a person to live in country of nationality and of unable to return to his country due to alert to the well-founded danger because his life is physical integrity is in danger. The fundamental difference between asylum and refugee status is in the asylum is generally to granted to the individual, and the asylum seeking the state does not have to explain the reason of offering of deny it. Refuge, on the other hand, is the humanitarian in nature of granted to the primary group, and the reside to status might justify the reason for refuge. In sense of legality of asylum, in general terms, the practice of protection and shelter to persons of different reasons and situations provided to the asylum subsists within in the international public law, in the fact that those persons who are considered under the unjust persecution. In the political persecuted are granted the asylum in the territory of the states or in the permits of diplomatic representation or countries that admit them. The political persecuted may be asylum seekers in the territory of the states of the premises of diplomatic representations, other countries they admit them. In the both case, the asylum seekers cannot be removed without authority of the diplomatic representative, since it's the request of diplomatic extraterritorially of violations of territorial sovereignty. It's important. Thus, international practice also allows asylum to be granted when is the person who are the places considered by diplomatic conventions to be extended of the national territory, such as the C2 embassies or consulates, the resident of the ambassador, military bases, or warship anchored in the foreign ports. Consequently, the grant type of asylum poses a delicate diplomatic situation within the practicing states, but in terms of the granted and the analysis of the event its denial. Always seeking appropriate discernment which allows distinctions between persecuted persons and simple criminal seekings to exempt themselves responsibility. Being the date of is no legal obtained is positive international law for states to grant asylum in the like that in many cases the right of asylum does not reflect more than competence on state allowed to persecution foreigners or enter to remain under in protection in territory and consequently or granting him asylum. In this sense, the so-called right of asylum in general has traditionally been understood to be the sovereign legal power of the states to grant asylum or refuge to persecute individuals under absolute freedom of decision by the states. However, the right of asylum has been generated to the individual, which has been enshrined in several countries through constitutional norms and instruments, but without having a binding of legal power of international level. What is purely enshrined in international law is the legal power of the sovereign states to grant asylum in this territory to any person who justify requests it. Is proved to that state in question is not under any conventional obligations. Must be recognized the even of the legal use by the states of granting asylum ban undoubtedly but established to international law. However, the elemental of opinion juris essential of the formation to the customary rules to do not yet seem to exist in the order to predicate a personal and individual right to the granting of asylum. It is also clear that under international law, the granting of asylum does not itself constitute a hostility act, and this is must necessarily apply equal to the accept by the state of asylum of possible statement by the asylum seeker that has suffered of fear persecution in this country are origins. In the way we care attitude of state of asylum, we interpreted an interface of possibility invitation in domestic affairs of the other state when persecution is presumed.
All right. So thank you so much, Andres, for a detailed account on asylum seekers and refugees, and also the legality of asylum. Because sometimes people think that asylum is not legal and that this is a very, you should get feel guilty if you are applying for asylum. But in actual, international law allows applying for asylum in other country, as you have just explained it. So, Andres, you have written a book on extradition. I was reading the book, and it is a very detailed account on extradition and also the multilateral arrangement on the extradition. As you have just mentioned about political asylum as well, I wanted to know that I personally feel, and according to the international extradition regime, I feel that political asylum is somehow in a gray area of the international extradition regime. So, would you like to explain it a bit about political asylum, and does it allow criminals to, live a free life while other criminals who are extradited on the same crimes?
Okay, thank you, Shahneela. Okay, we start to say the political asylum is considered as a right that a person has not to be extradited from the other one country to another for persecution for political crimes. Due to certain dangers that exist of the treatment of this and the possibility of violation of human rights. Big that in this case is susceptible to lack due process. Regarding the extension of the right of asylum, two scenarios must be distinguished. The first is the human right to asylum, the activity exercise of asylum and the tolerance of this exercise. And the second, the passive accepted that if territory of a state asylum is granted to the politically persecution. Political crimes are those that against to the government range of the state and that are considered harmful to the type of government in power. So it seeks to censure, factor, and acts to the consider certain to the ideology of the effect of the states in a certain way. Since the concept of political crime has been undergoing to progressive restriction over time. Thus, within in the international community, crimes against humanity and genocide, acts of terrorism, attempt against of the life of the president or head of state or against the member of his family. This is so-called the Belgian clause. Attack against diplomatic personnel, unlawful censure of aircraft, kidnapping, hostage taking, and illegal detention, among others, are not considered political crimes. In this context, the status of asylum seeker of refuge prevents extradition is so that state that grants the request and grant this status to individual mass conducting a threat analysis of the growing to the request of asylum or refuge. Because by granting this protection, it will be denying the right of request state to prosecute one of the citizen or a person who commit a criminal offense within this territory, or in some way cause damage to public order within its territory. Protection could be also provided to displaced person fleeing in a war, but only until repair can be carried out safely. Therefore, the concepts to extradition and asylum are interrelated to extent that of refusal of extradited person may imply to the granted to asylum. On the other hand, extradition means a refusal to grant asylum. This doesn't mean the extradition and asylum should be considered as simply two aspects of the same problem, but as two different of a diverse situation which coexist, each with the legitimate purpose. Finally, it's important to note that once asylum has been granted, it must be respected by the other states, including the states from whose territory the asylum seekers flee. Any act of intimidation, violence, kidnapping, or else are considered act to violation to territorial sovereignty and therefore unlawful act that give rise to international responsibility. Thus, the competence to grant asylum is inferring directly from the principle of territorial sovereignty of the states. An international practice on extradition reinforces that thesis, saying this without the existence of an extradition treaty, there is no legal obligation to surrender to request person. The state practice the refusing extradition of potential victims or political persecution is considered a customary rule of international law. In this sense, the state will be legal obliged to refuse extradition of offenses of a political nature.
All right, that is great. Thank you so much, Andres, for giving us details on how the political asylum is granted and which crimes does not come under the political asylum. Like you just said, the crime against humanity and crimes against genocide, one cannot give asylum in such cases. To further explain this particular issue, because extradition, I believe, is the least discussed topic here in international law. And the many people, they are confused to the extradition concept that what crimes actually considered to be under the extradition, like on what accounts you can get extradition and you cannot get extradition. So would you like to give us an insight uh, to our audience as well on this matter, that what crimes are considered for extradition?
Okay. In the extradition is an institution only for a criminal order signs is applied only for the commission of crimes and not for administrative offense or of a civil, labor, or family or else nature. Likewise, in order for the request to proceed, the extradition request must be framed and comply with a certain requirement with the criminal area, which means that not just any crime can be extradited. One of the main requests is the crime must be considered as such in above legislation. That is the legislation of the request state as well in the requested state. Another considerably important limitation is the crime must be of a little legal relevance. The penalty applicable to such crime must be no less to the 2 years, for example, do not impact is to on society of international community. Therefore, we can state that any crime can be ground for extradition as long as it complies with two basic requirements. First, it must be considered crime in both legislation, and the second is there must be a crime of legal relevance whose penalty is greater than 2 years, when I say. Since the need for extradition is based on the territoriality of criminal laws, on the one hand, and on the other, the possibility that individuals have today to transcend in a short time to space of state sovereign clear just in the existence. Without in many crimes, we argue punish it and fight against crime in which of the entire international community shall be interested will be significantly reduced, since the aim is so prevent legal action from being frustrated and thus is not shall be punished from going unpunished. The need for respect for the state sovereign and complies with the rules of each state in powers of the extradition is a tool of important relevance to avoid war conflicts. The intrusion of the other states to a territory in search of a criminal is cause of infringement to sovereign we determine two states can start war to another. So danger. In this case, the extradition allows to capture of a criminal without to need to enter by forces into the territory of another state. All this within the framework to the diplomacy of the people, respect for the territorial sovereignty of each state, and above all respects and international cooperation.
Right. So thank you so much for providing us an account on the crimes which are punishable and a person can be extradited under those crimes. You have highlighted a really interesting and an important issue of dual criminality. Uh, Maybe if you can explain a little bit about dual criminality, a crime which is crime in state A and also a crime in state B. Only then a person can be extradited. So maybe we can have a little bit discussion on this particular point. And also, this is very important to know that asylum is directly related to the states of benefit because you cannot challenge a state's decision on asylum or giving political asylum to an individual. So we start with the dual criminality concept and then we go to state sovereignty.
Sorry, I can hear the last part. You can repeat me, please.
Yes, so I ask you if you can explain to our audience a little bit about dual criminality. Like you have just mentioned, that a crime, which is a crime in state A and also in state B. So it calls dual criminality, right? So maybe you can explain a bit with an example or a little bit more details on the topic.
Okay, perfect. In the international law, we have to the principles of extradition. The principles of law are ruled to they are to consider as laws per se. They are applying in the supplementary manner of the ruler to the event that therefore gaps to the loophole. They are constituted by doctrine and aphorisms to enjoy general and constant accepted by jurisconsult and courts. The principle of we are considered to doctrinal guidelines are allowed to understanding of particular cases considered is an important source of law. They are applied in almost all branches of law. In our cases, the principle of international law. Many states adopt principles to obtain guidelines to specify to issues and specify to elaborate of international conventions and treaties. In this case of tradition, mechanisms of doctrinal understanding we use it by analogy and comparisons. Their spin principles are considered as an active source of legal figure to addition to international cooperation of interstate reciprocity on tied to extradition a criminal. The principles of extradition law are multiply depending of the point of view. However, the most important and essential to govern this figure of legal data in presentation below, consider the most relevant for these international laws. One principle is of double incriminatory. That's, without you say, perhaps the most important principles of extradition. This principle establish that in order to proceed with extradition of an individual, the act which extradition is request must be enforced and punishable as a crime to legislation of both countries, that is bad to legislation of request and requested state. It is essential to notice strictly necessary to the act from which the extradition request may have or receive exalted the same nomen juris. Another one principle is a principle of legality is very same to this principle of double jeopardy. It's come from the Latin nullo crimen nullo pena sine previa lege and constitute an individual legal to proceed guaranteed to virtue of which and can be interpreted we no act as a criminal or subject to criminal sanction is not to be expressly considered as such to tangible of effective norms prior of the fact. is to say the configuration of the crime must perceive the criminal act. The establishment of crime is not applied to the facts occurring in it, but procedure prior to it. The principle of legality in the international sphere related to the legal figure to extradition comes from the Latin nulla traditio sine lege, which means that in order of the extradition request to be processed and procedure, the act with the request is made from the which of offenders begin procedure must classified as a crime to punishment and such either international treaty or its corresponding laws to the state party. Another principle we can compare is the pacta sunt servanda. Pacta sunt servanda is an expression that comes from Latin, which can be understood as what is agreed is binding. This principle established to commit an obligatory nature of compliances with the agreement, treaty, or contract between the parties that this is singing is any convention must be faithfully complied with the parties in accordance with the has been agreed, regardless of the form of stipulation. In these basic principles of civil law international to contractual relations, however, is frequently applied in a both public or private international law. Um, Finally, the principle of speciality, this complements that sphere. The principle of speciality is one of the most notable within the subject. The application of this principle is restricted only to extradition matters and used to obligatory character within the celebration of this legal figure. This principle establishing of the person from whom the extradition request is made may not arrested, prosecuted, or convicted from any crime that was previously committed, and this is not contemplated of the extradition request. That is not to say that extradition may be only be granted of the crime which the requested is made, and the extraditable person may be only by tried from the such crime and not for any other than its full establishment in the request and in which requested state to give its consent. In other words, one extradition is granted, the requirement states that only prosecute to requested person for the offense establishment by the requested state and not for others. The requested state has the power to determine the offenses with which the request person may be prosecuted.
All right, great. So now we know about the double criminality and how states actually act with the extradition. All right, so it was a long pending session with Andres on extradition. We have been discussing about the session from a couple of months now, and I'm happy that we finally decided to do this, and we actually did it. Thank you so much, Andres, for providing us insights on such an important topic and an important issue of extradition. And I'm sure it's going to be a very beneficial and informative session for not only for students and also for researchers and the faculty members as well. I look forward to having more sessions with you on international law and the fields related to your expertise. Everybody, the session transcription will be available here in the uh, uh, here in the session below, and you can download the English transcript of the session. Until next time, thank you again, Andres, and I'll see you in the next session. Thank you. Goodbye.
Thank you, Shahneela. It's a great honor for me to be here today to talk about extradition and those theoretical elements to give rise to the important field of international law.
Thank you so much. Bye-bye.
Bye.